Good evening. My name is Stephen Leskin. I am an attorney in Portland, Oregon, and welcome to this dive. I do two of these webinars every month on a topic related to divorce law in Oregon. Tonight's topic is the differences between uncontested divorce, mediation, and litigation. This is not going to be a terribly deep dive. I've covered each of these topics at length in other webinars, but I will talk about what the differences are and when one is appropriate or not appropriate. I usually don't take questions. I usually prefer just to keep talking. When I get questions, they tend to break my train of thought, and then it's broken, and I get lost, and it takes me a while to get back. But tonight's not going to be a particularly well attended seminar, so I'm happy to take questions tonight. I'm also happy to take questions uh, tomorrow or next week if you want to give me a call to say that you were at the seminar and you have some follow-up, and I'd be happy to talk with you. So let's just jump right in. So uh, whether you are contemplating a uncontested divorce, and I'll come back to that in a little bit and what that means, doing uh, divorce through mediation, or you end up in the courts and are litigating your divorce, the final outcome in all three is the same. It's a general judgment of dissolution. It's the general judgment which finalizes the end of the marriage and puts you into single status. And there are two ways to get to a general judgment. One is by going through a trial, and the other is by agreeing to it. With uncontested divorce, um, you it's necessary that the general judgment is going to be resolved through negotiations or by agreement, actually, not by negotiations. Uh, and so usually an uncontested divorce is the parties agree to everything, and all that has to happen is that the divorce judgment gets written up in a way that reflects both parties' desires. So, for example, if both the parties agree that a certain amount of spousal support is going to get paid, that's fine. Uh, if they agree on how the house is going to be handled, if there's a house or children, how the custody, parenting time, and child support is going to be handled, that's fine. Then that can be handled as an uncontested divorce. In my experience, my deep experience as a family law attorney, um, I have found that really the only type of cases that are subject to an uncontested divorce is where there's no kids, no home, really nothing to argue over. Because once you start getting into the meat of things, there's always going to be differences, almost always going to be differences. Once you start getting into like parenting plans, if a couple has kids and you start talking about custody or parenting plans, there's usually not going to be an agreement at some point, and then it's not an uncontested divorce. So I have found that really the only real uncontested divorces are where a party just has property and debt and they can divide those things up. And usually when I'm the attorney handling an uncontested divorce, I'll say to the parties, before you finish the divorce, divide your assets. You know, you're going to divide up who's going to take which furniture or the cars or bank accounts. Those are all assets. And who's going to take which debt. And you're going to make those divisions and then do the general judgment. I find that way it's just much easier. If a couple is trying to divide up, household, just as an example, household furnishings, and they get into dispute over, their armoire, um, uh, you know, then it's not an uncontested divorce, but you know right then and there what item needs to be negotiated over. And that negotiation may be, well, you want the armoire, it's $500, I'll give you $200 for it. We'll split, you take your adjust and I'll take mine. Or you take the armoire and I'll take the bed. Whatever it is. So you can do the horse swapping then. And then at the end, when you're doing the divorce decree, you could easily write and easily agree to each party will take the personal property in his or her possession, or each party will only take the bank accounts that are theirs. So that's the nature of an uncontested divorce, that there's nothing to contest. The parties are in agreement. And generally, the only time you'll really get there is when There's no kids involved, no house, or the retirement. There's no sophisticated um, financial instruments. So that's all about uncontested divorce. Next on the list, mediation. So uh, in most of the counties in Oregon, in fact, in every county, the courts are required to offer some kind of mediation to divorcing couples. And uh, some of the counties provide mediation for any issue that can't be resolved in divorce. And limit some of the counties limit mediation to just couples with children. And so they just mediate over custody and parenting time. Uh, and the reason that the state has such an interest in mediating is that once people start talking to each other, and especially with a trained mediator, they're often able to resolve their own differences short of going to court. And the courts want people to settle so that it doesn't take up court time and they can handle more cases and get more cases litigated through the system. And so the courts have a program to try to get people to talk to each other and to resolve their differences uh, short of going to short of going to trial. So um, that's court mediated mediation, and whether or not you have to go through that depends on the rule of the particular court. In Multnomah County, for example, it's just mediation over children issues. In Clackamas County, I'm pretty sure that they will mediate any issue in the divorce. Okay, so that's mediation that's required through the courts. A lot of times people will hire a professional mediator, a private mediator to resolve their case. And that's appropriate when the parties can agree to mediate. If they can't agree to mediate, then the case will be litigated. Uh, so mediation, just to clarify some terms, a mediator is a neutral profession who will go back and forth to help a party resolve their differences. And so the process is voluntary. You don't have to get to an agreement. You could say, none of this works for me, and we're done with the mediation, as long as that's in good faith. Um, the differences just may be too great to come to an agreement on. And that's under all the mediation rules, whether it's a private mediation or a mediation to the courts, the outcome is always voluntary. The court can't mandate that somebody is going to voluntarily resolve all of their differences. So, private mediation couple hires a private mediator, and they go through mediation process, and uh, they may very well resolve all of their differences through the mediation process, and that would be terrific. Uh, Private mediation usually happens before a lawsuit is filed. Couple hire a mediator, such as myself, to resolve their differences, and then the mediator will help the couple come to an agreement. And if they do that and achieve an agreement, it's written up into the papers that are necessary to bring about the divorce, and those are filed with the court and signed by a judge, and then there's a divorce. And so that's mediation. The other thing I would say about mediation is that it has a lot of benefits. I started doing mediation myself when I realized just how awful litigation is, how expensive it is, how stressful it is, how public it is. And I eventually just decided that there's a better way to help people get through this, the hard time in their lives. And so I started doing mediation. I do it a little bit differently, um, uh, but that's why I started doing mediation because it's just a more efficient way. So mediation is generally less expensive. There's usually one fee for both parties. Um, it's quicker. The mediation can be completed as soon as the mediator can schedule it, or start the process much sooner than going through court. It's confidential. There's If you are able to agree to the terms, only the terms get written up in the judgment, and those are public. But how you got there, things that are said, always remain private. There's no need to go to court. There's no cross-examination. There's no judge. The parties maintain control of the entire process themselves. And so all of these benefits are what makes mediation so advantageous. On the downside, a mediator does not have any power, excuse me, that a judge would have in a litigated case. So, for example, um, suppose you're not 100% certain that one party is disclosing all of the assets. There's no way in a mediation to force that issue. In litigation, right, when you go to court, when you litigate, you can go to court and say, I don't think I'm getting all the assets, and the court can order the assets disclosed, or an attorney will have the power to issue a subpoena to a bank, or I shouldn't say or, and compel a person to attend a deposition where they can give a sworn statement, be compelled to give a sworn statement about their assets and liabilities. And so you have some measure of confidence that you will eventually find all of the assets of the marriage. So, um, um, where there's insecurity about disclosure of assets, mediation isn't appropriate, but litigation is. Another time when litigation may be more appropriate than mediation is when there's domestic violence. Personally, I think that like when I mediate a case and there's domestic violence, I personally think that I'm pretty good about separating out the power issues that are inherent in the dynamic and working to create a level playing field so that there can be a fair um, and impartial result that the parties arrive at. But that's not always the case. And sometimes a victim of domestic violence really needs somebody to speak on their behalf. They're so intimidated, so broken down, uh, so just broken that they really do need somebody else who can help them make decisions, help advocate for them, speak for them, give voice to their concerns. And so that won't happen in a mediation. In a mediation, um, uh, generally it's only the participants. Sometimes lawyers will attend mediation. A lot of times, uh, uh, lawyers will set up mediation and then attend. Uh, but usually mediation is just the parties. And so in a case where there's domestic violence, um, there you really either have to pay really close attention to who the mediator is and whether or not that person is experienced enough and a strong enough personality to confront an abuser and has the training to deal with a victim. Um, uh, and if not, then you may be better off in the case of DV being in a courtroom setting. The advantage in that case is that the attorney has the power to compel the production of documents if they're not um, produced, as I was just saying. And in a courtroom, you're only speaking to a judge. You're never speaking uh, um, to one another. The attorneys always speak to the judge, and that helps to reduce, believe it or not, that actually helps to reduce tension and keeps the focus on the issues at hand. So that's an overview of mediation and when mediation is and is not appropriate. So we're kind of on a continuum here, right? So the continuum is that this is a family with a easy marital estate, right? There's no kids. There's maybe some assets and liabilities, but there's not a home. There's not retirement accounts. Perfectly appropriate for mediation. I misspoke. Perfectly appropriate for an uncontested divorce. You get a um, more affluent couple. The marital estate is going to be more complicated. There's going to be a house. Maybe it's going to be kids, or if it's an older couple, no kids, but more assets. That's usually the balance, the continuum in the relationships. And so those cases are more appropriate for mediation. You don't need to go to court. You can talk through it and come to an agreement. Uh, and then you get the continuum continues where there's more conflict. The parties can't communicate where there's distrust or abuse. And so maybe at that point the continuum takes you into court. And then you have the benefit and safeguards that the court offers. Which gets me to an interesting point that litigation has become extraordinarily complex. I've been doing this for 30 years, and I just earlier today I got a motion that I couldn't make. I mean, it made sense to me, but whether or not the other attorney was doing it procedurally correct, I didn't know offhand and had to go look it up. And then even doing that, I couldn't find the answer. So, for somebody, so litigation has just become very, very complicated. And there's a reason for that. And that's because the court's job is to protect people's rights. And that's what courts do. And along with protecting people's rights has become more and more rules and safeguards until we are just ruled out. And um, so litigation has become expensive. It's become time consuming. Uh, I, as a lawyer, do things that I'm required to do, but don't really advance the client's case because it's in keeping with what the courts view as protecting people's rights. And so I can spend thousands of dollars on a middle income couple doing things that I have to do, but I know is not really benefiting them. And if I don't do them, I've malpracticed. Maybe like out of 100 cases, doing those things may benefit somebody, maybe. And so, you think, well, I'll just kind of do it quickly, but you can't. You have to take each case and make sure that you're not missing anything. And that just drives up costs. So, uh, litigation is, going to court, hiring a lawyer, going to court, and having a judge decide. Most cases will settle. 80% of cases will settle, um, particularly if there's mediation and the mediation is productive and uh, uh, the case will likely um, resolve. But if not, you go into court. I know in my practice that a day of court time is 10 to 12, maybe even $15,000 on top of what a couple's already spent. I misspoke. What my client has already spent, not the couple, just my client. So court is expensive, it's stressful, it's public, it's exacting, and there are a lot of ways that things can go south. You know, so court is risky. You're giving your decision making over to a neutral third party to make all the decisions, and that party may or may not have a good feel for your case. Maybe evidence doesn't come in the way you expect. Maybe the other side presents evidence that it overwhelms you, right? So, um, court is appropriate where uh, there's not trust that all the assets are being disclosed. A court is appropriate where somebody needs representation, like in the domestic violence situation I talked about. Uh, it may be appropriate where the couple are so at odds, they can't function together. There's hatred, there's betrayal, and they'll never get to a settlement because their emotions cloud any kind of rational thinking to get to a rational outcome. So, um, in those circumstances, court is certainly appropriate. And um, um, so that's the continuum between, simple to moderate to complicated. And one way of thinking about it, what route is best for you in terms of choosing the correct forum would be, can we agree to everything? If so, then it's uncontested. If, we're still talking, we have a good relationship. Uh, the relationship is falling apart, but we're still, have trust and respect for each other, and there's not integrity issues, then mediation is certainly appropriate. It's certainly quicker. It's certainly less expensive, um, private, less stress, and mediation is appropriate. Last cases where none of that is true. You don't agree on anything. Um, there's no trust left. Uh, then by all means you're going to be in the court system. Maybe you'll get it resolved through a settlement. It's likely the case will resolve through settlement. Um, or through the mediation process if it's available in that particular courthouse. You may be able to get a resolution through mediation. If not, then you're going to go before a judge, and the judge will decide. The last, I want to break down litigation into whether or not somebody should have an attorney or not. And so I get calls all day. People, they want to get divorced. They don't want to spend the money. They don't have the money. Um, and they, well, I'll go online, I'll find the forms, and I will, try to litigate myself. Like I was saying before, litigation has gotten extraordinarily complex and and difficult, and trying to like figure things out as you're going along, it's not going to happen. You're just not going to know what like the rules of evidence are, or where to find Oregon law, or where to find the administrative regulations for child support. Like all of these things come into play and more in a divorce trial, and there's no way you can be familiar with all of that. And so, if two people are unrepresented, the court's just going to do its best to sort things out. Um, but if one person has an attorney and the other doesn't, it's it's just not a good situation for everybody, for anybody, I should say. So, um, um, the way I see it is, if you have the money, uh, don't try to do divorce yourself. It's just you can certainly find a mediator to do a divorce pro se, where both parties are not represented. Um, and um, when both parties are represented, like as a divorce attorney, people pay me $300 an hour, my hourly rate. It's actually low by Portland standards for somebody who's been practicing for 30 years. Um, but when somebody's paying me $300 an hour, like they're paying me to make their spouse not look good, right? And so that's the dynamic. Both parties are paying their attorneys three, four, $500 an hour, so the other party doesn't look good. You can't get a resolution under those circumstances. You can't get a resolution under those circumstances. That's not going to continue to poison the relationship after the divorce. Maybe that's not an issue for you. But if there are kids, or um, you have a lot of history together, there's in-laws, there's still going to be social gatherings where you're going to paths are going to cross, or things like that. That's just a recipe for killing any feelings that a party may have for each other. Um, and so you want to think about, to my mind at least, you want to think about litigation going through the court as a last resort, if you have to do it and there's no option, because there are other options. And as I was just getting ready to wrap up, but I do want to say one more thing, and going back to uncontested divorce, and that's whether or not you can do an uncontested divorce yourself. And the answer is yes, you can download the forms from the state of Oregon, Oregon Department of Oregon Judicial Department, OJD, has forms that they've developed. They're not very good. They're very general. They're hard to understand, but you could use those um, to divorce. If there's nothing to exchange, there's no property, if there are no kids, there's not a house, um, the forms are going to get you divorced. If you don't need anything, you're walking away. There's not going to be any future, like there's not going to be any spousal support. There's nothing, no transfers of property in the future. The forms are perfectly, the state forms are perfectly appropriate in that limited circumstance. Otherwise, it's probably even best to have an attorney do an uncontested divorce. I would strongly recommend calling around to find out like what the prices are. If it's an uncontested divorce and there's like you just need the divorce, there's no, it doesn't matter what the forms look like. But I know that there's a huge variation between law firms over how much law firms charge. Um, I charge $2,000 to do it. I've heard of firms charging 5,000. I've heard of charging $8,000 to do a simple uncontested divorce. That, to my mind, is crazy. I've heard of people doing it for 500, attorneys doing it for $500. To my ear, that sounds a little bit low, but if they can do it, that's fine. It probably, in the end, it probably doesn't matter what matters is that the divorce gets through easily and quickly, and the forms aren't getting bounced back to the parties, which sometimes happen. So you can do an uncontested divorce yourself if the issues are really limited and there's nothing that needs to happen in the future, and you just really need the court to bless you and say, okay, you're divorced now. Okay, so that's it. That's uncontested divorce, mediation, and litigation. I hope that's helpful. If you have any questions, please give me a call. Um, my website is leskinlaw.com. It's leskinlaw.com. And I can always be reached through the website or send me an email. It's Stephen Leskin at leskinlaw.com. Thanks for watching, and I hope you found that informative, and have a good evening.